Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. So, before going to the topic, it is our regular practice that we recite preamble of the Constitution of India with a strong belief and faith that preamble our identity, preamble our divinity, preamble our soul, preamble our goal. So, with this commitment and sentiment, I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. Now, we are moving on to the 32nd lectures. That is, we are touching professional ethics, paper 3. On the last occasion, we have dealt with Advocates Act, because we asked ourselves, who are we? That is what enlightened souls also had asked. Who am I? Why am I here? For what purpose? So likewise, in professional ethics also, we have approached the topic, who are we? Is this only the dress, or is this our address? Are we belong to learned profession? Do we belong to noble profession? Yes. Nobility, and if we say it is a learned profession, it should exhibit not in letters but in spirit. We should live up to that standard. So what is the standard that is prescribed under Advocates Act 49(1)(c), which empowers the Bar Council of India to frame rules to maintain professional standards for the advocates. So the source for Bar Council of India to frame rules is section 49(1)(c) of the Advocates Act, which empowers Bar Council of India to frame rules. And there is a chapter 2 of part 6, which says that advocate's duty towards the court, towards the client, towards the colleagues, towards the society, and we should be always considered as a privileged community, a leaders, because our forefathers who belong to our profession has led the entire nation to get Indian independence. First President of India, Dr. Rajendra Prasad ji. Father of our nation, Mahatma Gandhi ji. First Prime Minister of India, Jawaharlal Nehru ji. First Home Minister, Sardar Vallabhbhai Patel ji. First Law Minister, Dr. B.R. Ambedkar ji. And even the earlier president also, Ramnath Kovind ji, he was also once upon a time advocate on record, and then senior advocate, then president of India. Therefore, you can all aim something big. Aim at something big that will make you big. So they have provided the standards, professional standards. And now what we are going to see is landmark cases on professional misconduct. Professional misconduct, where is dealt? It is dealt under section 35 of the Advocates Act. When there is a misconduct, when client finds that advocate is indulging in professional misconduct, a complaint can be, section 35 of the Advocates Act deals with professional misconduct. There can be a reprimand to the advocate. or suspension or removal from the bar itself, but provided it is proved. So therefore, dear friends, today I am going to deal with one case law, very important case law, landmark case law, which deals with whether as a lawyer, can we retain, can we exercise a lien over the case papers bundles when we are not paid by the clients. This is one of the questions repeatedly asked in our professional ethics, advocacy and professional ethics, because there is outstanding. When we see, we are engaged by the client, we render service. Once case is dismissed, client asks, who are you? They put a question to us. Until before that, they will say, we will बनाएंगे मंदिर, आपके लिए बनाएंगे मंदिर. Dismiss हो गया नहीं, आप कौन है? So reason is, dear friends, tongue, it has a twist. Till yesterday they speak one thing, today we will change. That is why everything is written. Because there is one maxim is there. Spoken words will fly, but written words will remain there. Therefore, sale deed. Therefore, everything is written. So, therefore, dear friends, in one of the cases, or the Saxena case, what has happened? That is a leading judgment. Because the Honorable Supreme Court has settled the law, whether the question before the Honorable Supreme Court was whether an advocate can retain the case bundles, brief, or he can exercise lien, a possession over those papers when there is outstanding dues from the client. That is the question. For the first time it had come before the Honorable Supreme Court. Before taking you to the relevant provisions, let me give you the brief facts. R.D. Saxena ji, an advocate, I will give you. The citation is 2000, volume 7 Supreme Court cases, page number 264. I repeat, 2000, volume 7 Supreme Court cases, 264. R.D. Saxena versus Balram Prasad Sharma. Balram Prasad Sharma. R for Rajasthan, D for Delhi, Saxena. So let me tell you the facts of the case in brief, dear friends, and then I will take you to the relevant portions. In this case, Mr. R.D. Saxena was practicing in the state of Madhya Pradesh, and he was engaged, he was appointed as a retainer for the Madhya Pradesh Cooperative Bank. He was defending the bank, contesting the case on the behalf of the bank. Retainership came to be terminated by the bank. Then the bank requested for the return of case papers, bundles. But instead of returning the case bundle, our advocate R.D. Saxena ji had raised a bill by saying there is an outstanding of rupees 97,100 rupees. Please pay the outstanding dues. Once it is paid, I will hand over the case papers to you. But bank disputed the fact by saying there is no outstanding at all. So where is the question of making a payment? So that was disputed by the bank. Now the cases are going on in the courts against the bank or on behalf of the bank. Without the case papers, the bank is unable to contest the case. Now bank goes to the State Bar Council, Madhya Pradesh, makes a complaint. There is no outstanding fees from our side, but case papers are being retained. We are unable to proceed with our case, so we are deprived. Because the fundamental right, Article 22 Clause 1 says they have got a right to consult the legal lawyers and representation, so they are deprived of. So complaint was made. Now the Bar Council, Madhya Pradesh Bar Council issues a notice to Mr. R.D. Saxena to ask for a reply. What do you say? This is in complaints of the natural justice, R.D. Altram Partum. Now the matter, he files a reply. Matter goes to the disciplinary committee of the State Bar Council. As far as the Advocates Act is concerned, it says, if I am not wrong, section 36B, it says when there is a complaint before the disciplinary committee, it has to be decided at the earliest. That means within 1 year, not beyond that. When it is kept pending for more than 1 year, it automatically, the Bar Council of India, that is superior authority, will withdraw the case from the State Bar Council and it will decide it. So in this case, State Bar Council did not decide the case within 1 year. So matter goes to the Bar Council of India as per section 36B. Now the Bar Council of India, considering everything, they found Mr. R.D. Saxena was guilty of professional misconduct and suspended Mr. Saxena from practice for 18 months. Now, Saxena ji was aggrieved out of the Bar Council of India order. He prefers an appeal before the Honorable Supreme Court under section 38 of the Advocates Act, statutory appeal. Now, for the first time in the history of Indian judiciary, the question arose for consideration is whether an advocate can retain lien, exercise lien over the case papers when there is outstanding dues from the client. Because before that, before this case was decided, there were difference of opinion among the Honorable High Court's judgment by holding that they cannot retain. Some says they can retain. Some courts they have said they can retain. So therefore, there was completely confusion. No authoritative pronouncement on this subject. So therefore, the Honorable Supreme Court considered the entire issues and they have discussed. How they have discussed, dear friends? They have discussed what was existing in Roman law, England law, and how the solicitors had a right of lien. Contract law was discussed. Sale of goods was discussed. What is bailment? That it was discussed. And how lawyers started existing earlier. Previously, our profession, what they are giving, narrating the story, it was beautiful. I request each one of you to read this judgment. Every word is a treasure. When you are getting it free of cost, you may not value it, but it is very, very important. The honorable judges have taken so much pain and taking us to the world tour about the existing of law. I will tell you, brother, I will tell you. So the Honorable Supreme Court has discussed and they have said the lawyers used to be in the busy market. They used to have a walk in the busy market. And people, those who are illiterate, poor, marginalized, they go and approach, please help us. This is our problem. So they go and help just as a pure service. But later on, litigations increased, ego got enhanced or inflated, so many problems. Now those lawyers who was walking in the market or public places, they seated in their place, like a chamber or the office or the home. The people after the sunset, they used to thunder the doors of those advocates and they will seek their help. It is also a pure service. But as a gratitude, once their grievance is redressed, client's grievance is redressed, as a gratitude, they will come and hand over something. As a matter of gratitude, not as a matter of right. So it is only a pure service to the litigants at laws towards the society. Now, when lawyers started focusing completely on those issues, what about their livelihood? What about their family? Where their children will study, because we need to pay money for school fees. We had to go to the market, purchase rice, wheat, whatever. We need to spend money. Therefore, when a lawyer started completely focusing on this profession, then he wanted money out of this profession. So earlier it was not a means of livelihood, but when he has concentrated completely on this profession, then they started getting money for their service. So this is how step by step they have increased. Now there is a question now, is it a profession or is it a business? They have reached to this extent. It is a debate. So therefore this is how it got originated. And the Honorable Supreme Court has said that when they are comparing it with the medical professionals, when the patient is having examined all all the reports were there, but doctor is refusing to hand over the papers, when client is not paying, when patient is not paying, then it will be a threat to his life. But generally doctors receive fees before they admit these patients. But the Honorable Supreme Court also has held it is far-fetched imagination comparing lawyers with the medical professionals, but it is equally affects their rights. Therefore, when a common man does not get the fees or he does not get the salary, what is the remedy available to him? The same remedy must be available to the lawman also. So he can always hand over the brief, but he wants to file any suit for recovery of money or any other recourse like that of common man, he has to do it, and he cannot retain the brief. Because when you retain the brief, he will not get the legal representation. If you refuse to give NOC, he will not engage a lawyer. So he is deprived of the justice, which is bad in law. That is what the Honorable Supreme Court has held. What about Mr. R.D. Saxena ji? They have said before this judgment, the law was little difference of opinion were there. Therefore, R.D. Saxena ji was in the bona fide belief that we have a right to retain. So therefore, suspension is too harsh for 18 months. Therefore, though they have found him guilty of professional misconduct, they find it is enough that we will reprimand him, we will warn him, and that warning we should not be treated as a precedent by other lawyers, because it is settled now. It is very clear to us. This is what they have stated, dear friends. Ultimately, they have set aside the suspension of this practice and they have only reprimanded him, but still he was found guilty of professional misconduct. Now, the judges' names are Honorable Justices K.T. Thomas and Honorable Justice R.P. Sethi. But in this judgment, I cannot leave any paragraphs, dear friends. Every word, they are beautifully worded. We need to treasure it. It is like Holy Bible for us. So let me finally tell you, everything was discussed. In our country, admittedly, a social duty, I am just reading the last paragraph alone, since I have narrated the entire facts, issues involved. In our country, admittedly, a social duty is cast upon the legal profession to show the people become light by their conduct and actions. We must be a guiding light to other society, other members. The poor, uneducated and exploited mass of the people needs a helping hand from the legal profession, admittedly acknowledged as a most respectable profession. No effort should be made or allowed to be made by which a litigant could be deprived of his rights, statutory as well as constitutional, by an advocate only on account of the exalted position conferred upon him under the judicial system prevalent in the country. It is true that an advocate is competent to settle the terms of his engagement and his fee by private agreement with his client, but it is equally true that if such fee is not paid, he has no right to retain the case papers and other documents belonging to his client. This is the law they are saying. Like any other citizen, an advocate has a right to recover the fee or other amounts payable to him by the litigant by way of legal proceedings, but subject to such restrictions as may be imposed by law or the rules made in that behalf. It is high time for the legal profession to join heads and evolve a code for themselves. In addition to the mandate of the Advocates Act, rules made thereunder, and the rules made by various High Court and this court for strengthening the belief of the common man in the institution of the judiciary in general and in their profession in particular. Creation of such a faith and confidence would not only strengthen the rule of law but also result in reaching excellence in the profession. So, this is how they have concluded. Ultimately, dear friends, what is the message here is the rule book might be there in the Advocates Act as well as in the Bar Council of India rules, but Lordship, Justice V.R. Krishna here, he has said it should be in our conscience. It may be there, but it will not be implemented. If there is in your conscience, you live up to the rules, and you should always make your self-contained rules. That is why they have said we have stated certain specifications. What is the duty? Whatever we have not stated, that means you are not supposed to indulge in those also which you are not expressly provided. You should ask your conscience and you should act as per your conscience. Rule must be written in your heart. That is most important. So with this, dear friends, I am truly honored by your presence. Thank you so much.